So we'll move on from that. And we're going to talk a little bit about court procedure now. And you are a tremendous educator. And I know that the Bowman Cup is now being awarded at the tax moot for students. And I know that you've done a lot of work and initiatives as far as education throughout your career. I want to talk a little bit about procedure, and because many in attendance are not litigators, we have tax practitioners of all different sorts in attendance, maybe I'll spend just 1 minute in talking about procedure, so what the questions I'm about to ask you will have better context. Is that okay? All right. So, in effect, after a claim is assessed negatively, then you would file a notice of objection. Following that, you'd file a notice of appeal. You get a reply from the respondent, which contains assumptions which you have to abolish. And of course, many individuals in attendance today are here because they're interested in seeking this course of action, because it seems like there's situations that are not resolvable. So, in effect, some of the procedures that you'll have would be, after you file that, there's also a potential for settlement conference, and you can have a settlement conference with Crown Counsel at any time. You'll have examination for discovery, which is in effect an opportunity to examine each other's witnesses and evidence that exists through books of documents. I'm trying to just make this very brief. There's opening remarks in court, so in other words, for a hearing. By the way, examination for discovery, that only applies to general procedure. The informal procedure doesn't have examination for discovery. Opening remarks is an opportunity where you're going to introduce the facts of your case at a higher level. You'll have examination in chief, where you're examining your own witnesses, cross-examination, where you're examining the appellant's witness, the respondent's witness, nay, yours. There's closing remarks, which is the end of the process. So that's kind of just in a nutshell what the procedure is all about. But I'd like to ask you some questions now that we have that boring stuff over.
Fire when ready.
Absolutely, absolutely. So I'm going to ask you a number of things, and I've managed to prepare some questions that I thought that you would be the very best person on the planet to hear from.
That's very nice, but sure it's not true.
Well, I'll tell you, in conversation with one Crown Counsel, he mentioned to me that, he says, well, you don't agree with Chief Justice Bowman. I said, well, actually, I do. But it turned out, he said, Chief Justice Bowman is not only the greatest tax court judge in Canada, but also in the world.
Very nice to hear that. I'd like to believe it, but I don't.
It is true. So anyway, I wanted to ask a few questions of you, if you don't mind, that I just jotted down on them here before coming over. First of all, what is the most important part of litigation?
Well, I suppose there are many most important parts. One that is of extreme importance is to define the issue. If you haven't defined the issue, the judge may do it, and he may get it wrong. Or the other side may define it wrongly too. So I think define the issue will certainly affect the manner in which you win or lose.
Mm-hmm. How important is the opening remarks as far as defining the issue?
Well, state them briefly, succinctly, and correctly. And not too long. Don't spend more than 10 minutes stating them.
I recall you being quoted as saying that if you don't win during opening remarks, you're not going to win during closing remarks. Do you remember saying that?
I may have said that. I've been practicing law for a long time. There's a lot of things I don't remember.
Is there truth to that? Is there truth to presenting the issues in opening remarks strategically in order to win, to gain the influence, to exert the influence during that time?
It's important to state the issue because that's what you've got to prove.
Fair enough. So how should facts be presented in court in general?
Briefly, they should go in tickety-boo.
Tickety-boo.
Yeah.
Okay.
Put them in quickly, succinctly, and sit down and call your witnesses.
Fair enough. Is there any danger of being caught off guard by a very cordial Crown Counsel or overly courteous Crown Counsel?
No, I've never run into that.
I remember you being quoted as saying not to forget this is war, no matter how courteous things are. Does that ring a bell?
Oh, yes, I do. Run into lots of very courteous Crown Counsel, too.
Yes.
but that doesn't mean they win their case.
Right. So when you're saying not to forget it's war, and as courteous as it may be, don't forget it's war. It's not a suggestion not to be courteous. We should always be courteous. We should always be cordial.
Mm-hmm.
But always remembering at the end of the day, it is war.
It is war, and you're there to win.
We're there to win. That's right. What advice can you offer in preparing witnesses for examination, for discovery, and for trial?
Examine them, cross-examine them, re-examine them, lengthy preparation, and they should be brutally and nationally cross-examined.
Mm-hmm. You bring your hands down a bit so that
Yeah.
Okay. What is your standard approach to a case, if you could say there was one?
My usual approach to a case is this. A, what are the facts? B, what is the issue? C, what is the common sense and fair result? D, I then look for some law to support that position.
Very good. Now, some were referred to you as being very results-oriented. How do you feel about that?
I'm quite proud of that.
Okay.
I think that the judge should be results-oriented.
Mm-hmm.
Darn many judges are not results-oriented at all. I think you should look at the result because, of course, you can test that result against your concept of fairness and compassion.
Now, you have counseled students on keeping their eye on the judge.
Yes.
Why so?
Why so? Because if you don't keep your eye on the judge, you don't really know which way you should be arguing. The judge may ask you hostile questions or difficult questions. Be ready to answer the judge and right away. Don't do as many counsel do. I say, well, what about this problem? I'm coming to that, Your Honor, and I will deal with it in a moment. They never do because they don't know the answer.
They're doing it to buy the time.
Something like that.
And the judges can see through that.
Yeah, most of them.
Yeah. All right. And when a judge asks you a question, perhaps it's through closing remarks or at any other time you should so choose to do so. Or say a judge makes an observation. How should we react?
React to it, take it seriously. Because the judge he's not necessarily hostile to it. He may be trying to help you. Mm-hmm. I can recall on a number of occasions I put a question to counsel, and I say, what about this problem? Oh, you're not going to trap me into that. And my answer is, I'm trying to suggest to you a way you can win your case. If you're not going to pay any attention to it, then I'm not going to do it.
Very good. There's wise words for sure. So how would you answer a client who asked you what's the likelihood of success of winning your case? It's probably something that you've heard many times.
You cannot predict it. There is no case I've seen, all years I've been practicing, that cannot be lost, no matter how strong your case is, how strong your facts are. You have a dozen Supreme Court cases to support you, and standing counsel on the other side. Even those cases can be lost.
And what should the objective, I do apologize, to what extent should a settlement conference be explored at an early stage?
Oh, you should. You should try to settle all things. You know, that's disappointing because you don't get into court, but it's still a very important result.
So you believe that any SR&ED claim, potentially, if it has merits, should be settled?
Yeah, but it shouldn't be settled arbitrarily.
You've been quoted as saying the practice of law, tax law, I should say, requires knowledge of arts.
Yeah.
Knowledge of the arts. Could you help us to understand what you meant by that?
So law is supposed to be a learned profession. You should know a little bit of literature and poetry and music and that sort of thing. It's not bad way of doing it. Yes, I think that art, at least that law is a learned profession, should be treated that way.
Now, we're seeing quite a few cases where there's an election made in the informal procedure. And we understand the difference in cost, but we're seeing situations where fairly substantial amounts of ITCs are being pursued in the informal procedure. Quantum tax law is being retained by a lot of companies for the general procedure as well as the informal. And we're seeing that there is a lot of claims in general that are going forward, or statements, notice of appeal for the general procedure, informal procedure, whereby there's a maximum of $25,000, where perhaps the claim, the ITC, could be hundreds of thousands of dollars. Mm-hmm. Do you think that the process of the general procedure, really the difference is, well, one has examination for discovery, one doesn't. The informal procedure, I would say, is by no means informal. I would say that the procedure would be very similar in general to the general procedure. Would that be correct?
Yeah.
So do you think that it would be...
What you're leading up to is you're asking for my view on whether or not the limit, the informal procedure, should be increased.
That would be a good question. I was more asking about the efficacy or the wisdom of saying, well, look, we're looking for 200,000. We have an entitlement in law to 200,000, but because it's too daunting to go for the general procedure, we're not going to do so. Mm-hmm. And that's what we see happening. And that was, so I would like your opinion on that.
Opinion on what?
On whether it's the examination for discovery and whatever additional issues may be. Obviously, there's costs that are potentially awarded against an appellant in the general procedure, which would not be in the informal procedure, and whether that would be something that companies should be considering. Yeah. So rather than see companies limit themselves and restrict themselves to the informal procedure, it isn't so difficult to go to the general procedure. But what is your thought on whether or not, now that you mention it, whether the limit on the informal procedure should be increased?
Yes, I think it should be.
What?
Oh, 100,000.
100,000? Be reasonable.
That's just off the top of my head. I don't know
what Justice Bowman, I wanted to ask you about the issue of contemporaneous documentation. Do you believe that at the audit level, do you believe that contemporaneous documentation should be the basis for determining eligibility, or do you believe that the requirement for documentation should only be evidentiary only? In other words, should be purely to support that the activity took place?
It should be primarily evidentiary, but I'm not saying that it should, that a claim for research tax credit should be excluded if there is no contemporary documentation. It should be. Depends on whether or not the researcher is believed. Mm.
You are aware that, and I know that you are, the 5 questions that CRA arms RTAs with, they've taken your 5 questions from Northwest Hydraulics, and they've made a slight revision to one of them to say that there's a record of the hypothesis kept as the work takes place, which really has put RTAs in a position where, they're now, at least in many cases, basing the decision on whether the work is eligible or not on the documentation rather than looking at the documentation as being evidentiary only.
Well, I would say that the documentation is the strongest evidence that you have in the field. So try to have it, but I'm not saying that's essential. I would reject scientific research claims just because there is no documentation. Depends on what they believe the taxpayer.
Yes, and you're not alone in that. I mean, obviously, there's been some very good decisions that have been covered during today's program that does talk about a more balanced view of documentation. Chief Justice Bowman, CRA has taken the position that trial and error is not eligible for SR&ED. Is this semantics, or what do you think about this position?
Well, I think that's baloney. I don't believe it at all. I think that a trial and error is one aspect of scientific research that goes into scientific research.
I think what they're attempting to say, and of course, I think what CRA has done is they've taken the term trial and error and they've created their own rendition, their own definition.
I don't have any doubt, for example, that Thomas Edison engaged in a lot of trial and error.
Undoubtedly. Good analogy. I would suggest that what they're really saying is there's no hypothesis that guided the work. But the term trial and error, and of course in Joel Theatrical, Justice Somerville had mentioned the same subject and said that he didn't know about any jurisprudence that stated clearly that trial and error wasn't eligible. So again, I think,
I agree with you.
Would you say there should be more training in this area for CRA officials?
They shouldn't need training, for goodness sake. They should be able to reach that conclusion on their own.
Fair enough. To what extent do you think that there is bias from some, in instances with CRA officials that might be purely academics, who might look at work that's being performed that isn't groundbreaking?
You're in a better position to answer that.
Well, again, our position is that in general terms, the CRA does a very good job at adjudicating the program. But I think that human beings is what they are. I think that no system is perfect.
Yep.
And I think if there's any improvement from our point of view, it would be to say, well, let's understand a little bit better from the point of view, because according to CRA guidance documents, the determination of an advancement should be made in the context of a company's own business.
Yep.
And what we have seen, now that you put it that way, are situations, albeit isolated ones, where there's a lack of empathy, for lack of a better word, for a company that's not doing groundbreaking work. They're incrementally increasing knowledge based on experimentation, research analysis, and yet, back to your original comment, that challenges faced by taxpayers can appear to be facts easily understood. And I think that boils down to the same thing.
Yeah. So
again, it's not a new problem. It's just a discussion as to what the problem is and whether or not there's any solution for it. In general terms, I think we've covered a lot of material.
We have indeed, yes.
In a relatively short time.
Fired a lot of questions at me.
But we really appreciate you taking your time, Chief Justice Bowman.
I'm glad to do it.
And thank you as well to David Sabina and to all of the people on the panel of the SR&ED Advocacy Group, Stakeholders Group.
Todd.
This concludes our program.
All right, thank you, Todd. If there's any other comments that the commentators want to make, Earl or David, feel free to make them now. Otherwise, we'll wait a minute and we'll see if there's any questions, perhaps, and wrap it up.